Okay, great. It seems like it worked. Okay, so to go back to the instructions, first you need to click the ReadyTalk link, enter your name, email address, and click register, and you will be given access to the meeting. If you have any questions throughout the presentation, please type them using the chat feature in the lower left-hand section screen. We will also open up the line for discussion at the end of the webinar, and we'll make sure all the questions that were asked do get answered. I will be sending over this presentation along with the recording. It will probably be early next week, Monday or Tuesday, but we will all have access to that. I'd now like to turn over the call to Cindy Daley, our Director of Policy at the Housing Alliance, to lead us.
Hi, everyone. Good to have you on the call, and I'm looking forward to hearing what's going on around the state. Let's start with introductions. I don't want to just do a roll call, although I do want to keep it brief. But if folks could chime in with who you are, what land bank you're associated with, and how long the land bank has been around. And then,
okay, and for this I will unmute the line.
Thank you, Val. And
the conference has been unmuted.
Later on, you'll have a chance to give us some updates. So, who wants to get started?
Allison Schmidt from the City of Erie, along with Mong from the City of Erie.
I'm sorry, along with whom?
The City of Erie, Chris Mong. He's
Chris Mong.
And we don't have a land bank yet, but we're in the process of doing the ordinances so that we can. So we want to learn from everybody.
Terrific. You can also individually mute with a *6 and then unmute with a *7. Who's next? Let's see. Let me see who's on. So I guess maybe we'll do sort of a roll call from the names that I show appearing here. Dave Calvario, you on? *7 to unmute.
Yeah, it looks like he's on.
Okay. David Feldman. You there, David? People who are logged on online, but I'm not hearing from them.
They might not have called in.
Yeah.
Actually, he just asked me a question here. I will respond to him.
Okay. Okay. Dean Moore?
Dean is here.
Yeah, can you tell us about your land bank, or if you're associated with one?
I am not. I'm with the eProperty Plus Land Bank Solution.
Oh, great. Okay. And where are you based, Dean?
We're in Fairfax, Virginia. There's
Okay.
currently 17 land banks that have implemented our product for their land bank operation.
Terrific. Let's see, who's next? Diana. Sure. Diana, are you on the
Yes.
phone?
Yeah. I am.
All right, you want to give us a real brief on your association with land banks?
Well, I've been consulting with York, Newcastle, and Johnstown, and all are in various stages of for passing ordinances and what have you, but nobody's gotten there yet.
Okay, so we've got a bunch more coming online next year, huh? That's great.
I hope so.
Ed Geiger, haven't talked to you in a while, Ed. You on?
Hey, can you hear me?
Yes.
Okay, I'm having a hard time finding the mic on and off, so I wasn't sure. I'm just interested in tapping into finding out what's going on. A lot of the folks I'm talking to are interested in still looking at land banks and just want to make sure I'm abreast of what's happening around the state. That's all.
Happy to have you. George Kelly.
Hi, George Kelly. I'm from Lackawanna County. We have a land bank that has been formed for about 9-10 months, and we just finished up our intergovernmental cooperation agreements, looking to acquire our first properties.
Great. Thanks. Joe Shockey?
It's Chuck. I'm with the Northeast Pennsylvania Land Bank, and we've been about 2 years. This October will be 2 years.
Great. Okay, who else do I have here? Justin Eby.
Yes, Justin's here. Lang County Land Bank. We've been in existence since July.
Terrific. Okay. Laura Northup.
Yes, I'm doing the same as I'm basically listening in for more information, and several of the clients that M&L is working with, Mullen Largan is working with, are either involved in land banks or looking into becoming.
Good. Thanks, Laura. Sarah Slater.
I am based in Pittsburgh with Pittsburgh Community Reinvestment Group. Pittsburgh hasn't started its land bank isn't up and running yet, but I am working for a nonprofit that's advocating for issues around those lines.
Terrific. Glad you're on, Sarah. Scott Henry.
I am present. And with the Erie Redevelopment Authority, and as Allison said, we're still in the ordinance development mode at the present time.
Okay, good. Steve what is it? Stephen
Novotny?
Sorry, couldn't quite read that. Thanks.
That's okay.
And
So I'm with
Go ahead.
I'm with Pittsburgh Community Reinvestment Group with Sarah.
Oh, good. Winnie.
Hi, I am on, and I am happy to be on and start these calls up again. It's great. I've been working with municipalities in different parts of the state to start land banks, most recently in Pottstown and Montgomery County, and I'm interested in hearing what everybody else is doing.
Thanks. Dave Calvario? Not on. David Feldman?
Yeah, I was listening on the online audio, so I called in.
Okay.
Right. I'm with Right Size Homes. I have been following and involved with the Philadelphia Land Bank, and I was just out at a conference last week in Detroit, and Donald Carter was presenting on some of the work that's happening in Pittsburgh, and I was up in Flint getting an update on some of the projects I'd done through the land bank up there a few years ago.
Terrific. Is anyone else on whose name I didn't call? Oh, okay, great. So everybody's got the video and not video, the online and the obviously you're on the phone, or you wouldn't be hearing me. Okay, so great. Let's get started then. I am very happy to introduce Dermot Kennedy, who is a tax lawyer and has done a lot of work with low-income housing tax developers, but also focusing quite a bit on the 501c3 aspect of this work. He formerly worked with the IRS, and we've invited him on to talk about land banks. Can land banks receive charitable contributions, Dermot?
And the answer to that question is yes, and good to be with everybody. I've worked in many of the places where all of you folks are from, and I've had the opportunity of working with Laura on several deals, which I'm appreciative. As we're all familiar, when we make charitable contributions to various different organizations, be it the United Way or our churches or whomever, everybody asks for a receipt so they can deduct it on Schedule A of their tax return, which some of us may still be doing since the extension date for filing our individual tax return is coming up next month on October 15th. Similarly, governmental entities, including land banks, are frequently asked for the same thing, to provide either what some people refer to as a tax-exempt number or a determination letter to prove that it enjoys the status as a tax-exempt or charitable organization. And also, as well, the statute that created the ability to form land banks in Pennsylvania provides specifically at Section 211A5 that land banks can be provided from private sources such as other charitable organizations or private foundations or similar entities such as that. So again, these entities will be inquiring and will need to see from the land bank that they are tax exempt, because many of their own operating agreements and their articles of incorporation limit their ability to make such grants to other similarly situated tax-exempt organizations. So we will be asked to provide evidence and proof that land banks are indeed exempt and are able to receive charitable donations not only from individuals, but also from other foundations. And individuals themselves will need substantiation if we are ever asked during the course of an audit from the IRS that we have to substantiate that we gave X amount of dollars to a land bank or we contributed land worth X amount of dollars. We will need some evidence to substantiate that deduction. And also as well, if you're dealing in the commercial realm, you may need to provide proof that you're exempt from sales tax, although the sales tax jurisdiction lies solely with the state and not with the federal government. Sorry, I should have moved the slide there. When you form a land bank, and the land bank law was only enacted into law in Pennsylvania on October 24th of 2012 as part of Public Law 1239, the Internal Revenue Service does not automatically provide or give you a tax exempt or a tax identification number. In many land banks where they're formed in Pennsylvania are formed in alliance or coalition with other existing municipal entities or political subdivisions. So if you are in that type of relationship, you can use the tax identification number.
Excuse me, this is Chris Houston, solicitor of the Harrisburg Land Bank. Has this conference call started, or?
Yes, Chris, hi. Thank you for getting on. Can you hear Dermot?
No, I can't hear him. We were on another line, and Joyce came on and told us to get on this line, which we just got on, so I haven't heard anything.
And do you have the instructions for logging on to the slide presentation?
No.
Okay, let's make sure you get that. Bear with us.
Cindy?
Yes.
The volume has been really low, not just for Chris. I tried to send him a point. I don't know if you can raise the volume or talk closer. Appreciate it.
Okay, so...
I will turn up the volume in my phone if that helps.
Yes, thank you.
Yes, that helps actually, Dermot. And I'm sorry, I missed, who jumped on late? I will forward that to you. We did have to switch the phone number this
Chris
morning.
Houston just joined, I guess.
Okay.
Right, Chris?
Because we do have a
Morgan, Washington County Redevelopment Authority.
I'm
Could
sorry.
you say that again, please?
Susan Morgan with the Washington County Redevelopment Authority.
Okay. Great. Thanks, Susan.
Also, Pat Owak from Veneta County Housing.
Also, Ann Lewis from Steel Rivers COG.
Okay.
Also, Casa Collins from Allegheny County.
Hey, Casa.
Hey.
And Lisa Kovalik with Clearfield County.
Hi, Lisa. Okay.
John Cromer from Philadelphia.
Hey, John.
Okay. Let me email those links, but in the meantime, and we'll be sure to get the presentation afterwards out to everybody. But I want Dermot to be able to continue.
And this is Chris Galato. I'm on the line as well.
Hey, Chris.
Oh, good afternoon, Chris.
Anyone
Sorry
else?
About that.
Okay, great. All right, yeah. So Val will send the login information around, but Kermit, if you would
Dermot.
continue. God, Dermot.
I'm not one of the green guys on the Muppets here, you know.
No, well, we also work with a Kermit, but at any rate, I'm sorry, Dermot. Yes, thank you. Sorry, please continue.
I'm not a frog, I'm Irish.
Both green, right?
Yes, exactly. That's what the common denominator is. But as I was saying, if you don't have a tax identification number from an affiliated entity, you can always apply for your own EIN by simply going online. The IRS has the capability. If you go to irs.gov and type in apply for EIN, they will guide you through the various different steps. They will ask you various different questions as to what type of entity you are. And you should also have the name and the Social Security number of the person who will be responsible for filing the first tax return. And at the end of that process, it will electronically give you an EIN along with sending you what you're used to getting in the mail, assigning an employer identification number. So governmental entities such as states and their political subdivisions are not generally subject to federal income tax. And political subdivisions of a state are entities with one or more of the sovereign powers of the state, such as the power to tax. And these typically include counties, municipalities, and their agencies or departments. And similarly, land banks are organized if they're organized pursuant to the enabling legislation, are also considered to be part of this general grouping of people. And the IRS generally considers that those charitable contributions to governmental units are indeed tax deductible under 170C1 of the Internal Revenue Code. And it specifically said if made for a public purpose, and the public purposes of a land bank are set forth under the legislative findings and purposes of the enabling legislation, and that's at section 210102 of the statute. It sets forth 5 different things that were of concern to the legislative and meet the criteria for the public purpose in performing functions of governmental entities. So if you give to a land bank such as that, you can get a charitable deduction on your income tax return, be you an individual or whoever entity you are.
Dermot, this is Chris Houston. I have a question there. So let's say it's a foundation that wants to give a contribution to the land bank, and they're asking for a determination letter from the IRS.
Right, and we're going to get to the various different alternative types of recognition you can receive from the IRS, including what is in the various different types of determinations and what you have to do to receive those later on in my presentation. So if you don't mind, Chris, we'd like to defer the answer to that question until we get to that part.
Okay, thank you.
Otherwise, it'll cut my presentation in half.
That's fine. I didn't realize. I'm sorry.
Okay. But also as well, from the private foundation's purpose, since Section 211A5 of the Code does permit land bank to accept funding from private sources, that private foundation will also have a concern that the criteria and the purpose for setting up this land bank will be permitted contribution in accordance with the Articles of Corporation or the bylaws or whatever governing instrument of that private foundation or public charity. In addition, an entity that is not a public or political subdivision but performs essential governmental functions is also not subject to federal income tax under 115 of the Code. And the income of such entities is excluded from the definition of gross income as long as the income is derived from a public utility or exercise of an essential government function, which in case of land banks, as I just said, is set forward in 5 different paragraphs at Section 2102 of the enabling legislation. And once it meets those criteria, then anybody who makes contributions to a land bank can, with proper substantiation, deduct those on their respective tax returns. And of course, the individual's ability to deduct tax returns will depend upon his or her own situation. So they will have to consult their own advisor whether it's completely deductible or whether there are other limiting factors of that taxpayer that would preclude them from taking an entire deduction in the current year. But getting to your question, Chris, in terms of what are the forms in which the IRS provides advice to taxpayers. And there are various different avenues that the IRS can elect to proceed in this fashion. We've all heard probably of private letter rulings, and this is a written determination issued to a taxpayer by an associate and chief counsel's office in response to a taxpayer's written inquiry. And it's filed prior to the filing of returns or reports that are required by the Internal Revenue Code as to the tax status of either a particular entity or the tax effects of a particular transaction. And the IRS every year on January 1st or January 2nd issues a revenue procedure, and it's always numbered number 1. So in 2016-1, the IRS issued a revenue procedure that basically sets forth a number of different things. It sets forth, number 1, what areas of the Internal Revenue Code the IRS is willing to issue a private letter ruling under. It also, in Section 7 of that revenue ruling, sets forth what you have to do to obtain a private letter ruling. And it also sets forth, equally as important in Appendix A, the various different filing fees that are associated with the IRS looking or agreeing to look at that revenue ruling. Equally, it sets forth areas of the Internal Revenue Code that the IRS either has sufficiently looked at in the past and is putting a hold on those sections in reviewing those sections of the code, or that it is, for whatever reason, because of new legislation coming down the pike or whatever, is unwilling to opine as to what the IRS's position is with respect to this. And it also may be true if certain items are under litigation in the tax court or the federal district court. A letter ruling is very onerous in terms of filing it. Not only do you have to set forth in detail the factual underpinnings of the case, you also have to set forth any controlling law that may be governing the status of the entity itself, the land bank, how it's constituted, what its affiliations are, what its associations are, what its funding sources have been, and what its plans are going forward, and also how each individual section of the code impacts or applies to those specific transactions. The filing of a request for overruling also, not only are you asking the government for this, but you're also attaching to that request for revenue ruling a proposed form of revenue ruling itself, so the government can adopt in whole or in part some or all of your conclusions. The good thing about a private letter ruling is that if it is in your favor, you can obviously rely upon it from here until whenever, unless the facts of the law changes. However, the bad thing about a revenue ruling is it gets reported to the district where you file your tax return. So if you file a tax return with a tax treatment inconsistent with that private letter ruling, it will almost invariably trigger an audit and get you selected for a tax examination. The other thing about a private letter ruling is it only applies to the individual taxpayer, and there's a section of the code that specifically says that no other taxpayers, including any other land banks, could potentially rely upon that private letter ruling. However, it does give you a general map of how the government is viewing or analyzing these situations, and does provide a significant guidance and insight into how the IRS would treat your situation if it was similarly situated. So a private letter ruling, a land bank can certainly go for a private letter ruling. I think it's onerous, I think it's burdensome, I think it's costly, and it's not just simply a one-off. It may involve meetings, one or more meetings with the IRS, which usually take place in Washington, D.C. at 1111 Constitution Avenue, and may take a lengthy, protracted period of time that may impact or may hinder your future plans. So my recommendation would be to defer, as a last alternative, the filing of a private letter ruling. The second type of advice that the IRS gives is a closing agreement. And unlike a letter ruling, a closing agreement is an agreement between the IRS and the taxpayer that agrees that the proper treatment of a transaction or a tax status of an entity is ABC, and then that will be the future treatment of the tax transaction or the ongoing status of the entity for the future as well. And so it applies both prospectively and retroactively to the transaction. Unlike a private letter ruling, it applies strictly prospectively. The third form of advice the IRS gives is a determination letter that we're probably all more familiar with receiving when we file a 1023 application. A 1023 application is an application submitted by an organization that is seeking to be exempt under a section of the Internal Revenue Code, most likely Section 501c3, which is the section all public charities are receiving their tax-exempt status. And we'll get to at the end of my slides. Maybe we'll go to it now, if I can find it. Here is an example of a determination letter that's issued by the IRS in response to an application I filed on behalf of an entity that was seeking to be treated as a 501c3 entity that had previously been a 501c4 entity. And this determination letter not only tells you the exact exempt status of an organization in whatever classification is accorded tax exempt status in, but it also tells you who issued it. It tells you whether it's a public charity or private foundation or whatever under 170 of the code, which will permit donations to be tax deductible. It'll tell you whether a return is filed, such as a 990, a 990EZ, or 990N. It'll tell you the effective date of the exemption so that a donor to this can rely upon the fact that the year in which the contribution was made, the entity was a tax-exempt entity and therefore entitles the donor to be receiving a tax deduction. And it says whether the contribution is deductible. So it provides you with a whole host of information regarding that entity that not only the entity itself is going to rely on, but any private foundation or any public charity or any donor or any other affiliated government entity can make a determination that this entity is indeed a tax-exempt organization and should be treated as such by whoever is dealing with it and can reasonably rely that it is in fact a tax-exempt entity. The next one is an information letter, and this is a statement issued by an associate officer director. Chris, am I answering your question in terms of what you're asking, or?
Yeah, I mean, continue.
Okay. So an information letter is a statement issued by an associate officer director that calls attention to a well-established interpretation or principle of tax law. It may be issued upon the request of a taxpayer, including a land bank, indicating a need for general information of, among other things, the entity's tax status. So this is a very valuable tool for entities such as land banks or political subdivisions or whatever. The last one is oral advice, which is basically informal discussions between IRS employees and taxpayers or their representatives about procedural matters or whether the IRS will rule on particular matters or how the IRS interprets various different things. And this type of advice cannot be relied upon in terms of estoppel or anything else like that, binding the government to a particular position or having reasonable reliance by the taxpayer that that is in fact the position the IRS may take subsequently in an audit of that or determination of the tax status of that entity. And so a land bank or a political entity must follow one of these 3 or 4 different avenues to determine to satisfy itself or satisfy a donor that it is in fact a governmental entity that is exempt from taxation under Section 115 of the Code. As I said, going through the revenue ruling procedure is very onerous, very cumbersome. It almost invariably involves the assistance of a tax lawyer, which also can prove to be pretty expensive.
Dermot, the information letter, I mean, basically they just outline the various types of entities, governmental units, entities meeting Section 115.1, or tax-exempt charitable organizations. It doesn't really, though, say what the land bank is. It's just an information letter, correct?
Well, what it is a letter issued by the Exempt Organization Division of the IRS, and there's a subsection within the Exempt Organization Division of the IRS located in Covington, Kentucky, that basically deals with this and is responsive to governmental entities seeking this type of issuance of this letter. And basically it's a letter that's named directly to your land bank, is not to whom it concerns or to the general public. It's concerning your individual land bank. It has your EIN number on there, your employer or tax identification number. It has your mailing address. And it basically says, you know, you are this type of political subdivision, or you are the type of governmental instrumentality, or you are an instrumentality of state created pursuant to some type of enabling legislation. And this letter, unlike the private letter ruling or unlike the application for exempt status under filing 1023, this is free. And it's been my experience that anybody who receives this letter and distributes it to the entity who's looking to receive it, be it a foundation or be it an individual or a public charity, whomever accepts that this governmental information letter as basically substantiation that this entity is indeed a tax-exempt organization organized pursuant to 115 of the, or exempt pursuant to 115 of the Code. So I have never, in my experience in practicing law, seen somebody represent, nor have I seen the IRS in examinations deny a deduction based upon the fact that the individual was only relying upon this governmental information letter to make his or her determination, or the foundation's or the public charity's determination that that entity, the recipient of this governmental information letter, was indeed tax exempt.
Because when I read, and I have one in front of me, when I read it, it doesn't say what you are. It just says here are the different types of entities. That's the curious issue here.
So the purpose in using that letter and presenting that letter, are you uncomfortable in relying upon that letter that the entity is indeed a tax exempt under 115 of the Code?
Well, because it describes different types of entities. It talks about governmental units. It talks about entities meeting the requirements of Section 115.1, and then it outlines the third alternative being a tax-exempt charitable organization under 501c3, but it doesn't say what the particular land bank, like I have one here in front of me, Philadelphia Land Bank, and it doesn't identify what the Philadelphia Land.
Yeah, and I actually called the IRS the other day to issue that letter right away prior to this call. And I spoke to the exempt organization division because I was able to pull the Philadelphia Land Bank's information off the Pennsylvania Bureau of Corporations. I asked them to issue it to as many people as possible, so I could, so people could see what that information letter is. But if your objective is, and you are limited funds, and you are trying to show or demonstrate to entities or organizations or individual donors that you are eligible to receive these charitable contributions, and you're eligible as a result of that to take a deduction on your tax return, I think this is an excellent starting point in terms of the alternative opportunities or avenues that are out there.
Right.
If you have to
yeah.
Yeah, if you have to file a private letter, and I never went through that, if you have to file a IRS Form 1023, that alone is a 26-page form.
Right.
It also has
that triggers then the annual Form 990.
Exactly, and it also not only triggers the 990, but it also has attached to it multiple exhibits and multiple schedules. Also, as well, it depends upon the organization documents that you have as well. If your organization documents do not have the right language in there, you may have to go back to your original documents creating your entity and file an amendment to your articles of incorporation or articles of organization to provide for the type of language that the IRS specifically wants to see in the organization documents, such as language prohibiting private endowment, such as language allowing for the dissolution and distribution of the assets of a land bank or whatever public charity is upon the dissolution of that entity. And
Right.
if you don't have any of those languages and you didn't go back and amend the articles of incorporation prior to filing the 1023, your application is going to get bounced, and the $850 that you paid for that application will be put into the coffers of the IRS, and then when you go back and amend your articles and remedy and cure the deficiencies in your initial application, not only will you have wasted probably 3 to 6 months, but you'll have expended several thousand more dollars.
Right.
And I have included in this packet as well, which maybe I can go to right now. Well, here's the 1023, first page of 2033. Here's the 990 that Chris was just talking about here. Let me see if I can. Here is the checklist for filing a 1023 form, and you can see it's onerous, I beg your pardon, in terms of all the various different things that it requires. And it takes a substantial amount of time completing this, and it got all the schedules. And also as well, if you are a entity that is seeking to do affordable housing, there's a whole separate schedule and whole separate series of resolutions that your organization has to pass in order to be ultimately granted the 501c3 status and have that stated in your determination letter. So for what I'm suggesting is, as a starting point for land banks and as a wise expenditure of your funds, and as the public is looking for some evidence or some proof that you are indeed a 115 entity, the IRS itself, in terms of its own examinations, in terms of allowing or disallowing the deductibility of contributions, the IRS looks as this being an acceptable form of substantiation that this entity has in fact sought this letter out and has distributed to different people. And when you call the exempt organization division of the IRS, and you can, as the representative or as the attorney for this, you can go ahead and call the IRS. The IRS will record your entire conversation, just to make sure they will later check you are who you say you are and the entity is who it is. And in terms of a starting point, I think this is a good starting point for land banks to be able to see. And as I said, in my 30-plus years of practicing tax law, that I have never yet seen this letter rejected as being a substantiation of the tax status of an entity. So I don't know whether anybody else in this call has shared the same experience or whether they've had negative responses or experiences with this. And the other thing is, not only do you have to file the 990, which itself deals not only the expenditures and the revenues of the organization, it deals with governance, it deals with whether the conflict of interest policies, whether the trustees have updated their questionnaires, a whole series of things. If you don't file that for 3 years in a row, you automatically have your tax-exempt status terminated, and you have to go back to square one and fill out the 1023 form all over again to get your tax-exempt status back. So if you're in the middle of an application for set aside for low-income housing, or you're seeking funding from whatever source, and you have your tax status terminated or revoked, it is an untenable predicament to find yourself in. So I think it's a good service that one of the few good services that the IRS does, in fact, and it provides it free of charge to a land bank. And I have in my, let me just see if I can move to this. Okay, I have in my slide here how to obtain a governmental letter, and I have the number of the exact exempt organization division. I have the number in there. And then you hit prompt 1 or 2, depending upon whether you want to speak to the IRS representative in English or Spanish. And then you hit prompt number 4, and then you hit prompt number 2. And also as well, one good thing is you're not on hold for a half hour. My experience is you're on hold for anywhere from 5 to 10 minutes, which is good. If you're having your attorney call on your behalf, the attorney will have to have filed a power of attorney with the IRS because of the provision on anti-disclosure rules, because of the confidential nature of the taxpayer information. So I think it's a good starting point for organizations to prove to third parties and donors that they are. And I think they can do independent research as well themselves to ascertain that 170C1 of the code does allow contributions to be deductible when they're made to organizations such as this. So that essentially concludes my presentation. As I said, I've got a copy of the front page of IRS Form 1023, the application for recognition of exempt status under 501c3, and also the return of organization exempt. If you have income of less than $250,000, you can file a 990EZ, and the 990EZ can be filed electronically. It is a 12-page form and has also multiple schedules attached to it, Schedule A and Schedule B, which deal with the income and the exemptions. But it's also got Schedule O, and Schedule O is where you have to set forth in detail the types of contributions you're getting and where you're getting contributions in kind, which are included as part of the gross receipts of an exempt organization. You have to figure out how you explain to the IRS how you calculated the value of the contribution, and for both the donor and the recipient of the gift.
Dermot, this is Chris. And maybe you covered this in the initial part of your presentation. I apologize, I wasn't on initially. But I mean, the basic issue is, and again, and you've touched on this a number of times, and that is the 170C1 status of land bank. So you're basically saying that they do qualify as that they are a 170C1, right?
Yes.
Okay, and that is because of how they were formed initially pursuant to the enabling statute. Is that correct?
Yeah, the enabling legislation, particularly in the and if you look at Section 2102, the legislative findings and purpose, where the General Assembly basically found and declared that the importance of preserving strong communities, the importance of preventing blight, the importance of reducing the threats and concerns and reducing police and fire department coverage, and all of these things are primary public safety concerns of a municipality, of a political subdivision, and that they're all meeting a governmental function and they're all meeting a public purpose for which generally contributions are eligible under 170C1 of the code.
And because they were created by a or perhaps several political subdivisions, they are deemed to qualify as a political subdivision?
Exactly, and also even if they're standalone, if they're created pursuant to an ordinance unrelated to a redevelopment authority or some other political subdivision or municipality, under the the language in the statute parallels many of the provisions in 501c3 to have limitations with respect to prohibitions on private inurement, upon dissolution, the assets are going to be distributed back to the municipality where the property is located, all those things are not being done for purposes of benefiting one individual or a group of individuals within the municipality.
Thank you, Dermot. That was really terrific. Does anybody else have questions for Dermot? Star 7 to unmute your line. Wow. We will be sending out the PowerPoint, so you'll have it, and we are recording this call, so you have the conversation. Nobody else?
Thank you very much, Dermot. It was excellent.
You're welcome, Chris.
Appreciate it very much.
Thank you, Dermot.
Thank you.
You're welcome.
And then you can star 6 to mute your lines again. I'm going to do a real quick legislative update. I have on the agenda to talk about the Realty Transfer Tax exemption for land banks. There are a couple of other bills that are moving, but I'm also mindful of time. So first of all, pulling up my agenda here. I think we've discussed on previous calls the issue of land banks paying realty transfer tax, or even in some cases absorbing that tax on behalf of the buyer. So there is movement to exempt land banks. And actually, as of now, as of July, land bank transactions are now exempt from the state share of the realty transfer tax. There are two aspects of RTT. If you haven't dealt with it, realty transfer tax, 1% goes to the state, and in most locations, 1% goes to the county, I guess, or the local government. There are some home rule municipalities that have raised it above the 1%. So there is an amendment to House Bill 1500, which actually is a fairly innocuous bill that recommends that land banks consider using some of their property to address homelessness. But because it was a land bank bill, the language was dropped in there just recently to exempt land banks from the realty transfer tax. In the meantime, that bill hasn't passed yet. So in the meantime, as the budget was being done, in June, early July, part of the package of bills that goes along with the budget bill is the revenue code bill. And so they were able to stick in language into the state revenue code, the section on the realty transfer tax that exempts land banks. But they weren't able to address the local issue via that piece of legislation. So the land bank is currently exempt from paying the state share, and hopefully in a few weeks will be exempt from paying the local share also. But House Bill 1500 is what you want to track. It is in the Senate now. It is, I'm trying to think whether it's still, I think, in Urban Affairs and Housing, or had just come out, but it needs one more amendment. We believe it needs an amendment at the request of someone in a home rule charter community to just add some language to make sure that that full local RTT is exempted. So any questions on the realty transfer tax issue? Again, star 7 to unmute.
Yeah, this is Dermot. I guess I see good things and bad things about it. Obviously, good things for the land bank in that it will make acquisition, disposition of pieces of property less expensive in terms of the closing costs. It will, however, have an adverse effect on Act 137 monies, where it's going to reduce the pool of money available to counties to make loans or grants to entities for low-income housing tax credit purposes.
Actually, it won't affect the Act 137 funds because they are funded with fees on the recording of deeds and mortgages. So that's a different fund. What it will affect is the State Housing Trust Fund, but our assumption was that these transactions will be small enough that it's not going to have a significant impact. And at the moment, the realty transfer tax money that goes to the State Housing Trust Fund to FAIR will be capped at $25 million a year, and so we'll probably hit that in a couple of years, and so having this exemption won't impact it. But the Act 137 and the Philly Housing Trust Fund, other county funds, are funded from recording fees. Other questions on the Realty Transfer Tax? All right. Stay tuned for that. I want to mention 3 potential sources of funds coming up. And they're not for operating land banks, but would be used for rehab or demolition or potentially some other work. So first is Senate Bill 486. And just like the Act 137 funds that Dermot mentioned, this would be an additional fee, a $15 fee on the recording of deeds and mortgages. Senator Argyle from Schuylkill County is sponsoring the bill. Because of the nature of the problem in his area, he's focusing solely on demolition. So it would be a county optional, it's not mandatory, but up to each county to pass an ordinance, to establish a fund, to impose the fee, and then to distribute the money for demolition. That bill passed the Senate, just came out of the House Urban Affairs Committee. It and the next one I'm going to describe are part of a package of bills that have been negotiated with the realtors who don't like such fees but have something else that they want to move. And so it may move in the last. We basically have 3 weeks of session days left, 9 days scheduled before the election. They have a couple days scheduled for after the election, but that's most likely just going to be ceremonial, saying goodbye to people and such. And I also have heard that they may, or at least the Senate may, cancel the second week in October, so basically bringing them down to 6 legislative days. So a lot of stuff is moving quickly, and then there's a lot of stuff that won't move. So that's Senate Bill 486. I'm sorry, I'm not sure if I said 486. There's also Senate Bill 482. Senator Brewster out of Allegheny County. A similar concept, a different way of going about it. It would be a county optional fund for demolition and rehab, and this would be with a fee assessed on property sold at tax sale. Up to 10%. It was originally written up to 10% of the purchase price. I had requested, after talking with practitioners, including a few of you, requested that we add or the assessed value. They changed the word to assessed value and dropped purchase price, and so now I'm going back and forth with them on that. But that also came out of the House Urban Affairs Committee and is part of this package of bills that are all tied up together. So we may see that. We've got the potential, again, for a nice source of money for rehab and demolition. Third, and not part of the package with the realtors, I'll come back to that in a second, is a movement to increase the Neighborhood Assistance Program tax credit. Now, this is just real briefly for those of you, if you're not familiar with it, Neighborhood Assistance Program gives tax credits on state income tax for corporations that make contributions to nonprofits that primarily work in impoverished areas, doing anything from crime prevention and job training, education, to housing and blight remediation. So probably you would need to be working with a nonprofit to do this. I don't think the land bank could apply directly, but unlike the other 2 funds I described where the land bank could do the demolition, could do the rehab, this would be better for properties that you are deeding over to nonprofits in the area. Currently, the Neighborhood Assistance Program is funded at $18 million. It's been at $18 million since the program started in 1967. And House Bill 2213 would increase it. It's currently written to increase it to $25 million, but I was told.
Could you repeat the House Bill number?
Yeah.
It got me.
2213.
Okay.
It is scheduled to come out of House Finance Committee next week, so it's still at the beginning of the process. But there's an amendment that will be offered by the committee chair to raise that number to $36 million. It probably won't have time to pass this session. We'll be back next session, but I am optimistic that it's moving quickly, and there is a comparable Senate version, Senator Fontana, I believe it's Senate Bill 243, that also has co-sponsorship by both the Republican and Democratic chairs of the Appropriations Committee. So that gives me a little bit of hope also. So I will be following those, and I've one more bill I want to, well, let me just throw this one in also. Also part of that package of bills that the realtors have been negotiating with legislators is a bill that the realtors have been pushing. It's not about money. This I'm talking to you more for those of you who do code enforcement or work with your local officials on code enforcement. This is a bill that addresses a problem they perceive in some municipalities that do pre-sale inspections and then hold up settlement until repairs are made rather than letting the settlement go through and and then requiring the buyer to make the repairs. And so what the bill does is it sets up a system of temporary use and occupancy permits and prohibits escrowing of funds at settlement, so just making sure the sale goes through and the buyer can get into the property. That's all well and good, at least as I understand the situation. But what the Housing Alliance has objected to is there is a small provision in there that says the municipality must give the new buyer 12 months to make the repairs. That time frame can be negotiated into a longer time period, but may not be shortened. And 12 months makes sense if you are thinking about how long it takes to finish the job. But if you're buying a property that has bricks popping out of the walls, that has toxic substances on the property, or even that has high weeds, we shouldn't have to wait 12 months to get those things taken care of. And so that bill has passed the House. There's a longer history to it that I'm not going to go into. It is scheduled for a vote by the Senate Urban Affairs Committee on Tuesday. The Housing Alliance continues to ask for an amendment to deal with that 12-month provision, but again, that is tied up in the package of bills that includes the county optional rehab and demolition funds. So that is House Bill 1437. 1437, and I'm happy to go into more detail with anyone offline if you want to. I'm trying to be conscious of time here, but let me open it up to questions. *7 to unmute if you have questions about any of those bills. Okay. So I also encourage you all to chime in. Tell us what is going on in your neck of the woods. Val, do you just want to unmute lines at this point? So what's happening? Anybody just buy a terrific property, or anybody who just got an ordinance passed and you want to chime in, or what's going on? You all asleep from my presentation? All right, somebody's not.
There was one thing. There was Conservatorship Act hearing in Philadelphia this week.
Yeah, David.
And one of the things that some of the council members are looking, I don't think they've introduced a bill yet, but they're talking about is to, there actually may have been a bill introduced, to waive municipal liens on properties that go through Conservatorship Act, because one of the problems is sometimes the amount of liens that are on a property. So I don't know if anyone else is dealing with that around the state with their conservatorship properties, if they've gotten local municipalities, counties, and school boards to waive liens on properties that go through Conservatorship Act.
Has anybody else dealt with conservatorship, which could be a whole other phone call, but anyone used that? Sorry, David. Okay. Well, we'll keep that in front of folks, though. I'm
put it out there for people to be open, be sort of cognizant of. Maybe next month they might have heard something. Yeah.
And Cindy, this is Winnie. Just to bring people up to date on Philadelphia's land bank too. The land bank issued a second RFP for 9 parcels to be developed as workforce housing, and that RFP is on the Philly Land Bank's website, and there's a briefing for developers who are interested on September 27th.
Great, great. What else is happening? Okay. Well, we have a new opportunity for you to share what's happening. If you think of something after you hang up, we are about to send out an invitation to all of you to join a new listserv that we're establishing on blight and land banks, so that you don't just have to call me and I say, I don't know, I'll call somebody else. But you can actually ask each other questions or post information about what you're doing. So keep your eyes open for that, and you'll be seeing in a few days, I hope, an announcement of that list.
I actually do want to, David, again, I have one other question. Because the tax, the waiving of municipal liens and all, occurred to me land banks already, when they take a property through the stated processes, those liens can get waived anyway. But if someone, going back to the main part of our presentation today, if an individual wanted to donate a property to the land bank and the property had liens on it, do those liens also get cleaned? What would be the process to have those be cleaned of their liens?
As I recall, and please others jump in, there is a provision in the land bank, in the statute, that says land banks stand in the place of the municipality under a statute which I can't cite the names of, but maybe 10 years ago, both the real estate tax sale law and the municipal claims and tax lien law were amended to establish a process for wiping off taxes, clearing liens for property, or municipal liens, for donated properties. And the process includes whatever municipality is approached, that municipality contacts the other taxing bodies, and there is a time frame, so if they don't get a response, they're deemed approved, that sort of thing. I can find that section and send it out to people, but that is in there. Has anyone else looked at that or used that?
No, I recall seeing that section, and it also provides that the municipality can actually assign its liens to the land bank, who can then dispose of them as well. One of the concerns that we have encountered, though, is where you have liens other than municipal liens, such as a federal tax lien or a Pennsylvania Department of Revenue tax lien, or some other lien that is of a fiduciary nature that encumbers the property of the individual donor or property owner. And I don't think those types of liens can be disposed of. There are provisions in the Internal Revenue Code and in Treasury regulations that you can ask for a no consideration discharge of the property from the federal tax lien if you can show to the IRS that their lien either has lesser priority than the other liens and there's no equity left in the property, or else that the property itself is not worth the doing anything with and doesn't have any current fair market value. And there is a section of the Internal Revenue Service that deals with these provisions. And similarly, with the Department of Revenue, there is both within the Department of Revenue and within their Chief Counsel's office a procedure where you can ask for similarly from Department of Revenue liens.
Would it be helpful to folks if we scheduled a presentation on federal liens on another call? Is that something y'all are seeing?
Cindy, this is Chris Galata. I know that Westmoreland encountered this situation with one of their acquisitions, and if you do schedule that session, you want to tap into April Kopas's knowledge on the subject.
Okay, great, thanks.
What type of lien was that, Chris?
It was an IRS lien.
Oh, okay. Well, there is a specific Treasury regulation that talks about no consideration discharges, and you actually discharge the property from the federal tax lien. You don't release the lien as against the individual liable party. Mm-hmm. So the IRS does have the capability and the legal authority to discharge the property from its federal tax lien without receiving any money, so long as you can show to the Secretary of the Department of Treasury that it has or he has or she has no fiduciary or no monetary interest in the property after all the other liens have been dealt with or because of the fair market value of the property itself.
Right.
Mm-hmm.
Thank you. Okay, so we will look into that and prepare something, and also a good topic for the list, sir.
Cindy?
Yeah, go ahead.
Oh, I'm sorry, Cindy. This is Val. I wanted to interrupt. I just wanted to say that we're very excited here at the Housing Alliance. We just opened up our registration for our Homes Within Reach conference early this week. We already have 100 people signed up for it, so everyone should have gotten communications about that, and we've put another great program together this year. And specific to blight and land banks, for that affinity group, we have for the lunch presentation, we have presenters from around the state doing a snapshot of their land bank experience. Let's see, for dinner we have Alan Malek from a Center for Community Progress. He's going to talk about the national scene in tackling blight there. And we just have a lot of great workshops, code enforcement. I know we mentioned conservatorship, land use and soft markets, to name a few. So the early bird deadline to save is October 14th. So just be sure to register, and we look forward to seeing you guys there.
Thanks, Val. Yeah, we're excited about that. Does anybody else have questions or things to contribute from around the state? Okay. Well, then we managed to keep this to about an hour, and so thank you all for getting on. And we are planning on getting back into our monthly routine, so we'll talk to you in about a month.
Okay, super. And I will get the presentation and the link with the recording out. Again, it'll probably be early next week, but I will get it out to all of you that are on the line. So thank you.
Thanks. All right. Bye-bye.
All right, take care. Bye-bye.
Thank you. Bye-bye.
Thank you.